The Foreign Affairs Manual defines a misrepresentation like this. As used in INA 212A6 big C small I, a misrepresentation is an assertion or manifestation not in accordance with the facts. Misrepresentation requires an affirmative act taken by the alien, and a misrepresentation can be made in various ways, including in an oral interview, in a written application, or by submitting evidence containing false information. And by the way, at least in my experiences of several thousand calls that I've received, it's usually in an oral misrepresentation because people feel they can get away with it the most. In determining whether a misrepresentation has been made, it's necessary to distinguish between misrepresentation of information and information that was merely concealed by the alien's silence. Silence, or the failure to volunteer information, does not in itself constitute a misrepresentation for the purposes of that 212 section. Now, the FAM, Foreign Affairs Manual, states that willfully is interpreted to mean, for that code section 212A6C1, is interpreted to mean knowingly and intentionally, as distinguished from accidentally, inadvertently, or in an honest belief that the facts were otherwise. In order to find the element of willfulness, in other words, that you wanted to do it, there must be determined that the alien was fully aware of the information that was sought and knowingly, intentionally, and deliberately made an untrue statement. For an alien to be inadmissible under that section, there must be clear, convincing, and unequivocal evidence that the alien made a willful misrepresentation. A willful misrepresentation for purposes of the statutory refers to the cases, the laws, provision entails voluntary and deliberate activity. So in other words, you need to know that you needed to know that you were doing this at the time you were doing it. The misrepresentation must be made with the knowledge of its falsity. In contrast to a willful misrepresentation, negligent is when you make a mistake, does not make you inadmissible. And that's from the Castameda-Gonzalez case. The Department of State, which controls the embassies abroad, has developed the so-called 30-60-day rule. And be careful with this one, by the way. To assist in determining whether you've misrepresented your intentions to a consular or immigration officer. The rule is applied such that when an alien who obtains a visa as a non-immigrant applies to all of a sudden become an immigrant, that's called adjustment of status, to a permanent resident, fails to maintain their non-immigrant status within 30 days of entry. What happens here, be very careful. For example, we have a lot of people who turn around and decide, for some unknown reason, I really don't know why, but I've talked to hundreds of these, that they're going to enter the United States, marry a U.S. citizen, and remain here. That's not allowable. Let's say you came to San Diego on vacation. You met somebody, and out of the blue that you didn't know before, and then you're crazy about each other, great chemistry, you decide to get married. That's one thing. But if you were communicating, had a relationship, and then you decide to fly in to marry them and stay here, that's not allowable. You actually have to apply for a fiancé, which is called a K-1 visa, or a green card from outside the country, and it takes you about 8 months to get it. But a lot of people try to enter illegally. Well, they don't realize they're entering illegally, but if they're entering by stating that they're coming to visit, and then all of a sudden say, well, I decided to get married and stay, it becomes a big problem. Now, the government will give you, a 30, 60-day benefit of the doubt. You have the opportunity of providing evidence that you didn't enter with a false intent if it's within such a time period. But also be careful. These people are very well trained. Very, very well trained. And, a lot of people have been told by various immigration lawyers, oh, go in there, wait 60 days, then do this, or wait 30 days. Don't do it. because you cannot answer all of the questions correctly. There are things that you do and don't do when you're in a certain position. And when you're asked these questions, you won't be able to overcome them. And I've seen this time and time again. A lot of people think they can get away with this, and I'm all for taking risks, but not with the law. With entrepreneurship is where I take my risks. But in this area, you want to be straightforward because surprisingly, for most of you watching this, you can get away with a lot more if you're honest to them than if you aren't. Now, another section, the Attorney General may, in the discretion of the Attorney General, waive, which means forgive, the clause subsection I of subsection A 6C of this section in the case of an immigrant who is the spouse, husband or wife, son or daughter of a U.S. citizen or of an alien lawfully admitted into permanent residence if it is established to the satisfaction of the Attorney General that the refusal of admission to the U.S. of such immigrant alien would result in extreme hardship to the citizen or lawfully resident spouse or parent, not child, spouse or parent of that alien. Now, that's what's called the extreme hardship waiver, and I'm sure you've heard about it. Evidence of extreme hardship includes emotional difficulties of family separation, financial dependence, serious illness, and other forms. And trust me, there are many other forms that can be used because a lot of people have gone to various lawyers who've said, oh, why don't you see a psychologist and tell them how depressed you are, or tell her how depressed you are. Of course you're going to be depressed. But if it's a standard depression of separation and nothing beyond that, it doesn't qualify under extreme. And in terms of financial hardships, not having two incomes over one, well, guess what? Everybody who's single only has one income. So that doesn't help you. So they're looking for extreme hardship. But if you don't meet these rules, as they stand, we call it on all fours, there are many other ways and a combination of factors. Let's say somebody has a 10-year bar and has been living outside, their spouse has been living outside the country for 10 years. And the U.S. citizen only gets 4 weeks off a year and spends those 4 weeks with their spouse, and as a result can't even see their own parents who live somewhere else in the country because they're trying to keep that marriage together, and the person is getting old. Let's say the person happens to be 55. In my opinion, such a case would make sense. I mean, what are you supposed to do? Wait until you die? The person has spent their 10 years outside the country, and they've done everything that they had to do. They made a mistake. They were young at the time, didn't know any better. In my understanding and belief, and this is actually a case that was presented to me just today, such a case would make sense. So it doesn't have to meet the black and white, and certainly don't listen to the advice of just going to a psychologist. Again, the government knows what they're doing, and these officers are very well trained. Now, evidence of extreme hardship includes the emotional difficulties of family separation, financial dependence, serious illness, and other forms, but also includes present and foreseeable future hardship. And that was from a case called the Matter of Shaughnessy, BIA case, Board of Immigration Appeals, 1968. The BIA has held that the common consequences of deportation, separation from family, or financial hardship do not, as I stated just now, without more constitute extreme hardship. The hardship to offspring who remain in the U.S. after the parent's deportation is a relevant consideration, although that alone is not extreme hardship. Economic considerations alone are not enough. A family member's financial status without the applicant is a relative consideration. The case law suggests that while demonstrating one factor is not enough to meet the requirements, a combination of the above factors could be enough to establish extreme hardship. In Palmer versus INS, the court found that no extreme hardship to adult children who were self-sufficient and did not depend financially on the alien. In Caramonte versus INS, the adult son's testimony that he would be sad if his father was deported was just not enough. Of course he'd be sad. The factors to be used in determining whether somebody has established extreme hardship include, but are not limited to the following: the presence of lawful permanent resident or U.S. citizen family ties in this country, the qualifying relatives' family ties outside the United States, the conditions in the country to which the qualifying relative would relocate, and the extent of the person's ties to such countries, the financial impact of departure from the country, and significant conditions of health, particularly when tied to the unavailability of suitable medical care in the country. In a recent decision issued by the Administrative Appeals Office, the alien was a native and citizen of Lebanon, and that person was seeking a waiver of inadmissibility under 212A9B and lowercase 5, which is a B, for unlawful presence, and INA Section 212, small I, for fraud or misrepresentation in connection with a previous fiancé visa, which is also called a K-1 application. The applicant had admitted to an ICE officer that he had entered the U.S. on a K-1 visa on September 22nd of 1999, but had no intention of marrying the woman who filed the petition. Well, what does that tell you? Because when you're the beneficiary, the person who benefits from a K-1 visa, fiancé visa, the whole idea behind you entering on a fiancé visa is you marrying that person who is your fiancé. So this person stated, I have no intention of marrying her. He later married a U.S. citizen and had a U.S. citizen child, and he was later ordered removed from the country and granted voluntary departure. He departed the United States in 2006, having accrued more than 6 years of unlawful presence in this country, and then sought a waiver of inadmissibility to re-enter as a spouse of a U.S. citizen. It was denied.